The Honourable Member, Alfred Naira.
E rau rangatira, mā tēnā koutou ki ako nui, ki ako rahi, tēnā koutou katoa. Mr. Speaker, that was probably the worst sort of grandstanding speech that I've heard as a new member in this House for over 50 years. And what concerns me is that that member can walk out of the House, can make those assertions, and yet if she was really serious about doing something about it, she would have subbed on the Select Committee, she would have heard over 270 oral submissions, she would have made a contribution that makes a difference. Instead, we just heard a whole lot of gobbledygook. But what's of most concern, she uses the statistics of everyday men, women and children who are suffering under family violence, and what the Minister has done in her wise leadership is to look at a bill that will actually address these issues. Mr. Speaker, in 2011, in April, the Cabinet directed the Ministry of Justice to undertake a review of the Family Court. This included the concerns raised by the public, judges, lawyers and counsellors. This is a wide consultation of all those key stakeholders. And this is what they said, Mr. Speaker. They found the Family Court was adversarial at times, placing additional stress on already strained relationships. Negative for children, not focused enough on their needs. It's not focused enough on the most serious cases of domestic violence, which was talked about, and spends too much time on simple private matters that are better resolved outside the court. It was too complex, too difficult to resolve these disputes. Mr. Speaker, the purpose then for the Family Court Proceedings bills is to ensure that it is modern, accessible for family justice system, that is responsive to children and vulnerable people, and is effective in that regards. Mr. Speaker, we have heard about the growing costs over there, raising up to 70%, around about $84 million to 142, and yet the number of applications for court proceedings has been lower. But Mr. Speaker, I want to just actually talk about some of the concerns that have been raised. I know that Mr. Little talked about in Christchurch, for instance, when we're hearing some of the submissions, he sort of regarded it as a bit of a shame that we were heard from one of the members of the expert panel, which was Mr. Gary Collins, and he spoke there. In fact, what he did say, I want to sort of give the fullness of that story, was that he talked about the good things of the bill, the intent of the bill. He applauded that. There was one aspect, which was Section 7A, that he was concerned about. So I just want to give the full picture. You're absolutely right, Mr. Little. There were concerns, but there were also some areas that the expert panel of judges in the judicial system, of those that were in the councillors as well, who actually gave an overall picture around recommendations which have been followed through. So just very quickly this. Family court lawyers. The new system, as they said, is a complex maze of procedures with different entry points, criteria and exemptions. So here's the response that's coming through from this bill, Mr. Speaker. The reforms will support people to resolve disputes out of court where appropriate. Improved information services, simplified court tracks and easy-to-use forms will be available to help people navigate for parts of the court system independently. The bill still removes the right of a party to choose to be legally represented in all family court processes, is what was also talked about. In court, people can have a lawyer represent them in a complex matters, such as for defended hearing or without notice applications. Judges will be able to allow lawyers to participate early in the court process if it would increase the chances of successful resolution. Mr. Speaker, it was talked about in regards to councillors. Now, I know and I've supported the work of the councillors, and as was talked about by Mrs. Dalziel, around the importance of their role. So there was a concern at the reduction in the level of counselling. Mr. Speaker, we heard from the relationship services, for instance, in their submissions. They talked about the fact that they were contracted for 4, they were averaging 3 sessions in all. So here's the response from this bill and from the Select Committee. Currently, pre-court taxpayer-funded counselling is available to anyone on request for up to 3 hours. Under the reforms, the current focus on private relationship issues will be replaced by a focus on resolving parenting issues and reducing conflict for the benefit of the children. Mr. Speaker, I also want to commend the Minister and also the Chairman of the Select Committee and our members of the Select Committee, because we went the extra mile. We actually even had a session on the parenting through separation. We saw the importance of this role around information that was given so that the impact on children was clearly understood by parents in this situation. Mr. Speaker, my final comments are this. We know at the heart of these matters are often the children. They are the ones that are most vulnerable. These reforms are designed in a way to improve the system, to be accessible, but where possible, where these disputes can be addressed outside of the court system, then they should. That's simply what we're doing here, Mr. Speaker. It's responding to the concerns. It's actually ensuring that there's a clear and direct process. It's accessible. And we know, Mr. Speaker, and we hope that it truly will make a difference to the lives of these children who often go through a very difficult circumstance. I commend this bill to the House.
Good on you. Well done.
Mr. Speaker.
I call the honourable member